from our interpretation, once the file was referred to this court, the orders expired today. That's our understanding. And my Lord, we are going to seek the court's guidance on the hearing of our application dated 18th October. Of course, we understand the recusal application today. But given the fact, my Lord, that our interpretation is that those orders would expire on the appointed date, which is today, when the matter was meant to be mentioned, our colleagues' understanding, my Lord, is that the application, in the public interest, be prioritized so that we are able to hear the application for setting aside of those orders. In any event, my Lord, the orders in question were issued by one judge. The matter has now been referred to a three-judge bench. And their nature is problematic, as mentioned by the court. And we would pray that in terms of aligning the hearing or scheduling the applications to be heard in cohort 2, that if possible, my Lord, we do not want to do anything else as the law. We would request the Lord that we be heard today if it's possible, because the orders expire today. I think Malaya Frederick Gumbo would just want to write something on that.
So, my Lord, very briefly, I only want to repeat what my Lord, I just wanted to indicate that I would not want to repeat what Senior Counsel Professor Pramojen has indicated, but just for completeness of record, there are two applications. There's one by the Honorable Attorney General and one by the National Assembly dated the 18th of October 2024. We are ready to do that for them as soon as the director comes.
My Lord, with your kind permission, Daniel Manson, appearing for the Law Society of Kenya and also for White Party Democratic Party or interested parties. My Lord, if the orders are to expire today, then that will be at midnight. My Lord, the day is not yet over. We have applications in the afternoon. We are also affected by those orders. And my Lord, I suggest after the applications today, then we can discuss that matter before the court adjourns. I thank you, my Lord.
Madam Kibe Mungai, on behalf of the petitioners, there are two issues. You can see the senior, the team leader of Unabopol, which is not with us in the council. That is the first thing that we intend to meet in the afternoon. And as far as we are concerned, the matter is premature and the hearing and determination of that applications for the simple reason that the issue and an order had already been made that will be first dealt with by the court after its ruling of yesterday was the application for the refusal. The other matters that relates to how we shall deal with the petition, and we shall deal with all the applications, including the first application for conservatory orders. Those are matters that, as far as we are concerned, are supposed to be dealt with by the directions. By this bench, if it continues, or by any other bench. And therefore, the issue, my Lord, of a back and forth on what is to be had first, the court has already ruled on that. And I believe we need to stick to that. And I am lamenting that even as we sat here, because we have sat a little bit late, there is some work we still needed to do with regard to the applications for the afternoon. So we'd like any other businesses that is supposed to be done when, for example, all Monday is in the afternoon, we go to the afternoon. But my Lord, on the directions, the actual directions that have been given by the court, there are three things actually that we would like our reactions on behalf of the petitioners. Number one, my Lord, is that in giving these directions, we are understanding that the directions are being made pursuant to the Mutunga rules, the rules of procedure that are applicable. My Lord, under the rules of procedure that are applicable, a lot of the petitions that were filed before last Friday and the ones that were filed even on Friday last week are maturing their last dates for responses. My Lord, as we sit here, we are yet to receive any substantive responses to those petitions in either halls from the respondents. And that will have an impact on how soon we can be able to deal with the substantive matters. So, my Lord, I would be expecting that as a further direction, everybody would be required also to comply with the Mutunga to the full. Now, the second issue is that in all the petitions, the subject matter was the impeachment proceedings. The impeachment proceedings was culminating with the impeachment that was done last Thursday and the facts as they happened on Friday. A lot of these petitions would require some amendment so that they conform with the last position, so that they are not termed as academic. So that, my Lord, towards that, the petitioners, including in the petitions where I'm participating, we have requested formally that we would want 3 days to ensure that any amendments are carried out. And then the respondents would indicate, they have been saying they can do things within a day or two. They will indicate how much time they need to do the responses. Because, my Lord, that would assist in ensuring that whichever bench is going to hear and determine this matter would be able to give final directions, because as you have said, these are interim directions. And number 3, in order to be able to determine issues for determination, and these are issues that we deal with when we are doing pre-trial, issues for determinations that are essential in a matter with so many parties, that would require close of pleadings. And the close of pleadings means that all the responses must be given. So that, my Lord, as far as today is concerned, I urge you respectfully that the first thing that can ensure we are moving forward is to ensure that the responses, in accordance with the Mutunga rules, will complete that journey. My Lord, if that is done, it is my view that we will be able to make some progress. In the meantime, my Lord, unless there is any other matter, because there was no other matter that was to be dealt with except directions, we would be happy to leave this place as soon as possible so that we arrange it in the afternoon. We are most obliged.
Just
I think my...
Because I'm not speaking right now, so you can have some response on it. Your Lordship, for purposes of clarity and for purposes of not addressing the gallery anymore, permit me to draw the attention of Council for the Senate to the notice of motion that was filed in respect to the conservatory orders that were granted. The judge sitting in Kilgore, Your Lordship, was categorical that he granted prayer number C, even as we await Senior Counsel Paul Mwete to come in the afternoon. The wording of those prayers was so explicit that if my good professor had the opportunity of interacting with the document, which I believe he has not, would have come to the conclusion that the orders were drafted in this manner. That pending the hearing and termination, of this application inter parties, this honorable court be pleased to grant the orders that were granted. That is therefore, to mean, Your Lordship, that question that Senior Counsel was raising has no sitting in the pleadings before you. Number 2, Your Lordship, since we are here for mention and in the afternoon we are coming for the application for recusal, and I have heard the advocates for the respondents insisting on the urgency to hear the application for setting aside, Your Lordship, it is important for the court to note that that application is not predicated on any response. And therefore, if I were them, I would be seeking guidance on how to file their replies. Your Lordship, I hope you're following. He doesn't seem to be following. Why do you say that? But why did you say that? But let me leave it at that.
Thank you. I think that is.
My Lord, on a very small issue, we do confirm that for His Excellency, the Deputy President, Gachagua, as the petitioner, we have not received responses from the respondents. So it is important that first of all we get direction for filing of responses, because as we speak now, we have not received those responses from the respondents.